So if hopefully you've seen our case study of Ken, and Ken will probably be the sort of client who gives you a ring and goes, I've just got a basic question, and what I'd like to do is just probably do a basic will, and then you think, okay, well, and that's when the dialogue starts. That's when you start talking to Ken and starting to unpick what it is his story is, what his views are, and actually it'll inevitably become clearer that he might want a simple will, but the reality is infinitely more complicated. So the first thing we can do is sit and listen. The first thing we do is, get your cup of tea, sit down, get your pad and paper, and just let them talk. Excellent, nice to see your cup of tea there, Emma. And yeah, Ken will sit there and will start telling you his life story, and the skills we have in this job are inevitably sitting and nodding and going, oh yes, is this, tell me about yourself. Okay, so so you're married, divorced, you've got your new wife, that's great. And then we start to find out about the children with Down syndrome, which inevitably goes, okay, so we've got a slightly more complicated situation immediately there. We've got a family where there may be a little bit of discord. We've got a family where there's a second marriage. There are adult children who will undoubtedly have their own views of what their father should and shouldn't be doing, regardless of what he thinks. They will probably know better. And the notion of what is the right decision for Ken and his family. And as a professional, the first thing you're going to end up walking this tightrope of what does the client want? What does the client think he wants? What do you think the client should have? And how do you balance that up when inevitably you start having conversations around the kitchen table with the family that say, well, Dad, are you sure that's the right thing? And do you remember that Christmas when, you gave my brother a better Christmas present than me? And I think you should try, even that out. So we've all been there. We're always going to be there. And I think that taking the time to just take a breath now, go back to basics and think about the Kens of the world, about what sort of things we should be doing. So once we sat down, we've got our picture of Ken and his family, and the fact that he's got early diagnosis of dementia, which we know is again going to be a flag for future issues. What's the first thing we talk about? So probably we talk about Ken's wish for a new will, because he's probably thought about this, and people are quite good at understanding they need wills. And I don't know about you, but I've had to stop watching any sort of daytime telly over lunch because, dear God, is it depressing. I've been sold wills, funeral plans, and I think, my God, if I was, if I was retired, I would be panicking about my life. So it's been quite helpful for me to be able to get a bit of a feeling for what people who are vulnerable and perhaps a bit isolated might be thinking. So I think the first thing is, Ken, you want to make a will. What's prompted that conversation? Well, I know it's the right thing to do, and I want to do right by my family. Now, what is doing right by his family? Now, we all know testamentary freedom, testamentary capacity. These are all really things that we're going to be alive to, sitting there and talking to Ken about his children and his needs, particularly with his son who's got Downs, and therefore we don't know what sort of future he has, how independent he's going to be. So really, there's so much scope at this point to draw up a will that is a simple will, actually. Gives everything to the 3 children. Off he goes. We know it's a properly executed will. Preferably if we can do a supervised will signing, that's incredibly helpful. Then we know Ken's got peace of mind that everybody who's going to get money is going to get it, and it's going to be okay. So However, and I won't be the only one, actually Ken might need a bit of sort of pointing in the right direction and saying, well, you know, a basic will that gives everything three ways, what's that going to do? Have you given any of your children a stack of money at Christmas? Have you given them a deposit for a house? Oh, well, there was that time that I paid for my daughter's wedding. And again, with his son with Down syndrome, that's going to be something that we need to look at the vulnerability of the next generation. So Ken, with his diagnosis of dementia, is immediately going to sort of make you check very carefully that he complies with all the testamentary capacity. But then what does his son need? Is giving him a lump sum the best thing for him? Is he going to be able to manage that? And then suddenly you're outside the realms of a basic will. You're outside something that you can readily pick up, you know, in WH Smith's and crack on and just draft. And that's where our skills as professionals really comes together, to sit there and say, well, look, I know what we can do. I know what is in my carpet bag, like Mary Poppins of tricks. What do I think fits your circumstances? So the will is something that, you know, as we know, clients just think it's a bit of paper, and that's because you can just buy them for 20 quid in Smith's, and you absolutely can. And for some people, great, if you sort of happy to do that, and you've got a very straightforward family, and you've got a family who, you know, are never going to argue and don't think that they've had been slighted at Christmas, then great. However, how many families do we as professionals genuinely see like that? The more you dig, the more you realize that what on the surface seems like a sensible family has undercurrents. And I did get surprised sort of relatively recently when I sat down with clients, and they are probably the first clients I've ever sat down. They went, no, never had an argument, never had a crossword. There's no way our family would, you know, would fall out. And I was like, yeah, right. And then the family came in to do some signing of some power of attorney papers, and they were absolutely delightful. And, you know, I had to eat my words, and I thought, you know, do you know what? As we stand here today, you are lovely, and I'm really delighted because you have made my day. I've just been proved I'm a cynical old lawyer, and really nice to have come across somebody who actually seems to be okay. So, wills. And in the current climate, wills are going to be even more contentious. I don't know if anybody's been sort of keeping an eye on locally to Bristol and Bath. We've had Royds Withy King have come out in the press and said that they've supervised a will signing remotely, even though we know this to be something that is contradictory to the Wills Act, even though we know that this is not the supervised in the same room, because there's been lots of chit chat about this. Royds have come out and said, yeah, we've done it, and, you know, we're going to give this a go. It may be that it's absolutely emergency measures, and they're going to get it re-signed, but it's generated quite a lot of chit chat on social media about people and thinking, is this right? Is this going to be valid? And I guess the answer to that is it going to be challenged? When the will goes to probate, if it goes to probate, will the probate registry pass it through? Will it need to go to the registrar? Will there need to be a court order? Will there be family members who come out of the woodwork, who use that opportunity to get their foot in the door that the will wasn't signed properly? We just don't know. And I think one of the things that we always have to do as professionals is sit there and say, well, we know that there's risk. We know that there's risk when we're doing anything, even the tightest of attendance notes at meetings and capacity assessments. You're only told what you're told, and you end up not being told the stuff that then turns out and bites you at the end. And that's where we as professionals really need to be looking very carefully at what's going on behind the curtain. We need to looking at the client and listening to what they're not saying, often as much as what they are saying. And again, this is getting harder for those of us who really been heavily reliant on sitting in a room with a client, with a cup of tea, watching their body language, listening to what they're saying, watching how they're getting in and out of the chair, which you know can indicate physical frailty, but mentally might be absolutely sharp as a tack. But they might be in pain, they might not be, they might be struggling. That's a lot harder to get that feel for what people should be thinking about. So again, with the coronavirus overlay, we're going to be in interesting times, and those of us who end up doing contentious work are probably going to be very busy. Those of us who are doing the work in a non-contentious fashion are needing to be pretty careful about keeping notes. We're not going to get this right, of course we're not. We can just do the best we can, but just because we're not seeing clients over the table in our offices, in their homes, doesn't mean that these issues aren't going ahead. It doesn't mean that we don't have the family members in the background telling dad what to do, what not to do, and talking to each other as a family and going, well, what do you think the right thing to do is? What do you think dad should be doing? So again, extra caution for us at the moment and our colleagues, because guarantee, like any time you pick up a pen to do a will, something's going to come back and haunt you. Extra caution at the moment is just going to be your friend. Whether you know whether you want to sort of have extra pieces in place for capacity assessments, whether you want to have additional attendance notes, you know your clients, you know your practice, you know where you're comfortable. And often, you know, as a slightly cynical lawyer, I might say the talking to the family is a blessing and a curse, because the family might be saying, well, I think this, you know, dad should do this and I don't get on with my brother. But at the same time, they may be able to help you with a bigger picture that dad perhaps hasn't felt comfortable telling you. So as ever, all we can do is our very best. We're all trying our best with our clients, and let's do what we can. So going back to Ken and his family, he's got a cast of members around him, and every client you've got will come with a whole host of people involved, whether that is spouse, children, siblings, friends, carers. Very rarely will somebody be so very isolated that there is not somebody in the background. And for those clients that are working with other professionals, so I've seen sort of people we've got on today, and I've worked with a number of you with other clients. It's going, tell me about them. I mean, I'm a solicitor, so I'm coming to this cold to do legal work. You're sitting down and talking to these people about their finances. You're talking to them about their health. You're talking, you know, you've got a different perspective. Tell me what that is. Tell me who this person is that they might feel a bit intimidated talking to the solicitor. You know, in the time I've been practicing, I've seen clients, you know, go from sort of, you know, getting dressed up to come and see the solicitor to not at all. But there are still people who do consider it intimidating coming in to an office. Again, what does your office look like when you are in the office? Are you in a sort of concrete and glass sort of big building? Are you in a smaller, sort of much more accessible something in the high street? Different clients, different requirements. A lot of clients I see at home, whether that's mobility issues or it makes sense. I used to work in North Wales, and a lot of my clients were farmers, and nothing quite beats getting your wellies on and going stomping around their land, because that's where you get a feel for who they are. So back to Ken and his family. So we've touched on Ken's will. Who knows what his will is going to look like? I know I think he should have. He may just completely disagree with you. we know that we know Ken also has dementia. Now, this is going to trigger the conversations now about powers of attorney, long-term care. What does this look like? How does it get funded? Now, this is an absolute sort of minefield for people. I think in sort of time I've been practicing, and there's somebody who very much started life as a private client lawyer. I was trained in college, you know, what clients do is clients, you know, get older, they do their tax planning because they're going to drop down dead. And when they drop down dead, we deal with inheritance tax planning. That's all very nice and neat. What I've seen, and it coincides with the introduction of the Mental Capacity Act in 2007, the Care Act from 2014, and its associated legislation in Wales, is that we are seeing an infinitely more frail clientele or client base. Somebody I was talking to said, you know, yeah, actually it's that twilight zone. It's that twilight zone between being okay and, you know, you've got your retirement planning and you've kind of got this vision of what your retirement's going to look like, and your kids are going to be growing up and your grandchildren and all this. And we're okay with the fact that we're going to be dead, because when I'm dead, I know my children are looked after. What's become prevalent is this extreme old age, is this very later life stage, this multiple comorbidities that people are living with, and this is very real. We're seeing you know, a lot better understanding of dementia. For those of you who know me, I'm a trustee of a charity called Brace, and Brace funds research into dementia. So part of the benefits I get from this is I get to see a lot of the reports. So people are submitting applications for grants for research, and we're beginning to see things like, yeah, we think you can start to see the signs of dementia 10 years, 15 years before a formal diagnosis. Well, that's quite a game changer. Whereas historically, we might have had people coming across to us, you know, and their forgetfulness and their impaired capacity is really obvious. What we're now seeing is, well, maybe what's that impairment? Is that a diagnosis? Should there be a diagnosis? And what's the knock-on effect of that? So we go back to Ken. He's got early onset dementia. He may live well with dementia for a long time. And one of the big campaigns we've seen from, you know, so the big charities is like, you know, I'm not suffering from dementia, I'm living with dementia, which is a really positive message for those who have it. As a lawyer, I sit there and go, if you have a diagnosis of dementia, we now know you have an impediment and an impairment that could affect, that we know will and can affect your capacity. So going on to the Mental Capacity Act, you sit there and go, right, back to basics. Do you have capacity? I have to assume you do until proven otherwise. And again, the onus is on me as a lawyer to sit there and go, even though I know you've got the diagnosis, I'm confident you still know what's going on, you still know who you are. You may have some issues with certain aspects of your life, but others you're fine with. The diagnosis of dementia, we will cover, you know, we all know about doing wills, but the dementia aspect, I consider is going to become more problematic when we look at long-term care. Because as soon as somebody has a diagnosis of dementia, we know that they have an illness that means that unless they die from something prior to the dementia getting them, to be quite crude, then they have an illness, for that is what it is, that is going to deteriorate, and they are physically going to deteriorate, and they are mentally going to deteriorate, such that they are going to be dependent. They're going to be dependent on family, they're going to be dependent on social care, they're going to be dependent on health care, and all these things are fine whilst you're sort of going along and around your business. What is going to be difficult is when people realise that they need care and then they have to pay for it. because that's when the trigger's going to come in, that you're going to say, right then, so you need to pay for care. You know, if you have assets over 23,250 in England, you're paying for your care in full, unless you're paid for by the NHS. And we'll come on to the NHS funding, so I've seen some questions sort of back and forth about that. And I've never met anybody who's who's happy to pay for care. You know, I will not be the only person who's had clients come in and go, right then, I want to give my house away because I don't want to pay for care. And I go, well, I understand the sentiment, and I'm very sorry that, you know, you don't want to pay for care, but the reality is that if you need care, you will need to pay for it. So that's legislation. That's what we've had for, you know, a long time. We don't have community hospitals in the way that you might remember from your parents. We do have care in the community. We have care at home, and unless you've got family members who are able to provide that, you're buying in a service. And saying to clients that you have to pay for care. Well, I don't want to. Okay, but what if you need it? What then? Oh, well, that's a bit different. Won't the NHS pay for it? So, well, you'll get your prescriptions, you'll get a district nurse if you've got an ailment or an injury, but the social care stuff, no. And simply giving away your house does not mean that you won't need care. It means that you don't have an asset to pay for care. It means that you will be asked to pay for your care from your own funds. If you have given away an asset, such as the house, we all know about deliberate deprivation, and you can't do it. What my question is, what about those clients who are trying to do tax planning because their health is pretty good and they've got, you know, on the face of it, a good 7 years plus in them, but we have a diagnosis of dementia, or we're beginning to see symptoms that because we're better, because we are better informed, we're understanding our precursors to dementia. Where do we as lawyers, where do we sit? Do we sit there and say, well, we know that this person we know they've got capacity, we've cleared that off. We know that they've got a tax planning problem, and we know that we can make gifts, we can put assets into trust, we can make gifts to children, all the classic inheritance tax planning things we are all familiar with. But where do we stand? And I'm not professing at this point to know the answer. Where do we stand if we know that this person's got an illness that might mean that care is on the horizon? And the hardest thing with this job that I find is that the people with very little money, the state will look after them, and that's not a problem. The people with all the money who can happily pay £1,000 plus a week for care fees without even thinking about it, they're also fine. What about those people in the middle? And it is a big bulge of people who have worked hard, have saved, maybe have a little bit of inheritance, and want to do right by their children. And because of advances in medicine, they're living longer, but they're not living well longer. Where do we stand on having those conversations with them and saying, well, you know, you're probably going to be okay on the inheritance tax planning, but where do we stand on the care fees planning? Are you putting yourself at risk? Are you putting your family at risk by making gifts that may, if somebody's going to be really cute about this, considered to be deliberate deprivation of assets? I don't know. I mean, I would, you know, if anybody's, you know, had experience of this or has been thinking about this, I would really welcome a conversation, because it's one of those things that, you know, it might be just really academic at the moment, but I just wonder whether this is what's coming. We know about the austerity pre-Covid-19. We know the issues with local authorities and how little money they had. We know what people were struggling with. When you throw in what we're going through at the moment, it's even more complicated. And I don't know sort of what people have been experiencing with clients who've perhaps been in hospital, in out of hospital, hospital discharge. The point at which they're going, we're not going to do a care assessment, we're not going to do a financial assessment, we're not going to do an NHS continuing health assessment, we're just going to move you out of hospital, home to a home as quickly as possible. We'll deal with the paperwork afterwards. This is I've got a couple of clients who are going through this at the moment, and it's really something that I think we're only scratching the surface of this at the moment. So what I would say is that there are no right answers. There is no right answers in this job. And, being a lawyer long enough and you go, that's the whole point, isn't it? That I say something and somebody else says something else, and maybe we can negotiate, or if not, we'll get a judge to decide. What I really want to sort of talk about, and I'll come on to the questions that have been coming through, which is great, is about collaboration. It's about working together. It's about taking a step back and going, I can't do this by myself. And I think for me, I've always been one for collaboration and picking up the phone and asking questions. And, there are people on here today who have been enormously helpful and continue to be enormously helpful to me to go, I don't know. It's probably something that I should know, but thank you. Basically financial advisors, and the SFE forum, for those of you who are members of SFE, is a phenomenal resource, and it's just such a good way of understanding that you're not alone. Ultimately though, we can't remove risk. We can't remove risk in this business, but we can reduce it. We can reduce the risk to our clients' family, those people who consider, like Ken's family, who might be seeing a bit of early inheritance because Ken's got some money, I've got power of attorney, or I might be getting power of attorney. I'll just get my conservatory a bit early. It's about having conversations going, if you don't know, maybe somebody else does. And then what I often find is that I'll ring somebody up and go, look, I'm not entirely sure about this. What do you think? And they'll go, oh, that's a good point. And then we can thrash it out. And often you find that it's not clear cut. It's not easy. It's not straightforward. And ultimately, collaboration with your clients, your families, your fellow professionals will all do a lot better if we can work together. And when you get your Ken rolling in at 5 p.m. on a Friday, before a bank holiday, because he's going on holiday for Tenerife for 2 weeks and forgot to mention that he hasn't got a will and he just wants a simple will, and suddenly you go, this is on me now because you've asked me, and I know we can refuse to act for people, but often we end up starting to try and be helpful, because by our natures, we're generally in a profession that would want to do the right thing by people. You'll get Ken's family, you'll get one man and his dog coming through. And honestly, we are living in extraordinary times. The legislation and the case law that is coming out is coming out rapid fire at the moment. Every court protection case I read, every ombudsman case that I read that comes through, all these articles that come through, I think, we're really beginning to see the impact of this aging population, of this better understanding of illnesses like dementia, to use the umbrella phrase. And you then throw in the Coronavirus Act 2020 on top of it, and we've got a huge opportunity for some very complicated situations to arise. And as we are seeing with perhaps the sort of lockdown fatigue, the kindness that people have been showing each other, going, oh, it's okay, don't worry, we understand that was done under tough circumstances and under tough times, may wear off. for those of us who are, who are regulated, what are our regulators going to say? I mean, the SRA and the Law Society have been quite clear. They said, well, your obligations remain the same. The law hasn't changed. The law on how you draft a will and execute will has not changed. The law on getting a power of attorney signed has not changed. All these things have not changed, even though everything else has changed. These fundamental building blocks of our profession really haven't. The Coronavirus Act stuff, yes, there is change there, and that we just have to work through. So yeah, that's my sort of thoughts on Ken, on the workplace, or on how we work together. So I'm going to just have a scout through the questions, and please do, if anybody hasn't chucked anything on there, please do. We can have a look at that. So I can see here, so I've had a few questions in before the start of this. So getting wills re-signed, it's going to be case by case basis. Some of my clients that I knew and I met before lockdown, we were in the process of doing this. They're quite sensible. They know what they needed to do. They're on will number 15. They're probably going to be quite sensible at getting the right person to sign it. Those clients who are perhaps more vulnerable, who are going to struggle, and I think, well, if you're shielding and you're in lockdown, getting your will signed is going to be much harder. So I will be looking at everything very carefully. We are doing supervised wills if possible. I swear in the last sort of 8 weeks, there was one day when it threw it down, and that was the day I was outside signing a will. You couldn't make it up, could you? So yes, I think getting wills re-signed could be the right answer for a lot of people. It might be something that you're quite comfortable with because you know that your clients are sensible and they will have done it properly. COVID-19 coronavirus having on care, well, quite apart from the care home deaths, which are frankly terrifying, the statistics and the treatment, it is very much the fact that the pragmatism, if I can use that phrase, of hospitals and care homes are just saying, we're just doing what we can. We know we would like to be doing financial assessments and NHS assessments and all these things that we know we should be doing in best interest decisions, but we just don't have the opportunity at the moment. And that, I think that's where we're going to see things really having an impact down the line. I've got clients at the moment and they're like, well, I've been told that dad's got to pay for his care and they won't do a finance assessment. And I say, well, I can, we're talking about a local authority that hasn't introduced the easements that they're entitled to under the Coronavirus Act. But the reality on the ground is they haven't got all the staff in. They were overstretched anyway. They're just going to go, I can deal with one thing at a time, and that's physically moving somebody who's probably vulnerable from a hospital to somewhere hopefully they're less vulnerable, whether that's home or a care home after hopefully a COVID-19 test. And that's very much the human impact. The legal and financial impact, we're going to be seeing that rolling out for the coming months. So what I'm saying to clients who are talking to me is very much just keep your records in order. Just write it down, ask the questions, see what they've said, get it in writing. 101 lawyering, get it in writing always. Hospital discharge and NHS CHC assessments, again, same thing. I'm talking to somebody just now who's going to pay for care for a vulnerable relative because they want them out of hospital, even though the hospital said we think they're entitled to NHS funding. The family, and I said, that's quite an unusual dynamic for the hospital to volunteer NHS funding and the family to say, no, I want them out and I'd rather pay for it. These are unusual times. Potential fraud, I think so. I think vulnerable people, I've had at least 2 or 3 cards through my door going, hey, can I help you with your shopping? And I thought, I've no idea who you are. And it's all been done out of a sense of civic duty and community, and it would be lovely. And if it is legitimate and genuine, that's fantastic. But it would be so easy to just take those pre-printed cards, put your name down, ring Doris's doorbell, go and do her shopping. Yeah, I think, you know, let's see what the outcome is when we've got some more statistics. Jeanette's, yeah, basic human rights in care homes. It's terrifying. I think to me, it's people are panicking. They just do not know what to do. I've been talking to care providers, and they said we have just had, quite frankly, some of the most terrifying weeks, months of our careers, because do we buy PPE? Do we not buy PPE? What does PPE look like? What should I be getting? What should I be doing for my staff? Should I be furloughing staff? Where does that leave my vulnerable client? Where does that leave me? Where's my duty of care as an employer, but as a care provider? And my feeling is, and having sort of sat in on some other conversations, is that the sympathy will wear off. The sympathy for you had a window of opportunity to get your ducks in a row, but that was my mum. I think that's where things are going to start getting a bit tricky. Interesting that Devon have suspended CHC assessments, but Care Now are still triaging. Yeah, I've been. I was asked by a client to sit in on an advocates meeting for a gentleman who doesn't have power of attorney. His daughter is in disagreement with the local authority as to what he should have, and they said, well, we won't run the meeting if the lawyer's there. So we are treading softly at this point with that one. So it's interesting to see that no advocates included in the assessment process. There's clearly an increased nervousness about lawyers over and above the normal fear that or advocates that we're going to be actually poking holes in what people are saying, because, hey, unfortunately, the law is a backstop. The law says, don't break it. People would be up in arms if it was a criminal law. But because it's not criminal law, that's okay. No, it's not. It really isn't. So it's something that I will also be keeping under review as to how long we're going to be kept out from meetings. Yeah, and then where we got here. Yeah. So Ben, yeah, it is absolutely. Ben's question, leaving them open to challenge. It is, and I think that our duty as professionals, anything that we're coming across of this nature, we need to be highlighting it. We need to be sharing knowledge. If we've got somebody who's got the ear of the authorities, let's collate information and share it. Nobody's out to be particularly adversarial. We're out for best practice. We're out for getting the right outcome for our clients. But it's very hard when perhaps again you're sitting in isolation, thinking, "Is it me? Am I at the wrong end of the stick?" So this for me is this is really interesting to hear that other people are experiencing this. Yeah, the do not resuscitate forms. Well, I mean, that was an early casualty of the pandemic, wasn't it? That people I think it was in South Wales, that please can you fill in a do not resuscitate form? Says the GP surgery. What a way to undermine what is actually a very valuable and powerful document. I absolutely. I think for those people who don't have powers of attorney for health, don't want powers of attorney for health, do not resuscitate forms, all those things, letters of wishes, statements of wishes, advanced decisions, they're really important. And if we can still reassure clients that that's a good thing to do, then I think we should be doing that. And I think there's going to be some, I think Compassion in Dying are doing an interesting webinar in the next 10 days or so, and that's going to be about this specific point. And they've got medics coming in talking about the CPR and about that. So Compassion in Dying is a charity. They produce advanced decisions. So I will be watching with interest to see what their recommendations are. Yeah, the welfare checks. Yes, I've had conversations with clients going, I've had good innings, I'm okay. I'm going to do a do not resuscitate with the GP because I'd rather have a bed for somebody who needs it. It really has concentrated the minds. I think, I don't think I've ever seen will writing get so many headlines as early on with panicking about things. And I think that we need to keep that under review and see what people want and keep spreading the message. Question from Ben about position between formal diagnosis and symptoms. Yes, I think absolutely. I think that it's when, a diagnosis is a line in the sand, in the sense that we know that there is a diagnosis. A presentation of symptoms, I think anybody who presents with symptoms that might lead them to have some confusion when they're talking to you, it's maybe just a case of saying, look, well, today's perhaps not a good day to have the conversation. Let's try again next week. And we all have good days, we all have bad days. It could be something as simple as an infection that is a temporary problem. So diagnosis is easier in one sense because you have got something to hang your hat on. The presentation of symptoms, that's again, we're just creating bigger grey areas. My sort of feeling is that if we've talked to a client who was confused, to keep it generic, and even though there's no formal diagnosis, if 6 months down the line they then get a diagnosis, is that creating an opportunity for somebody to challenge us and say, well, it clearly wasn't right. Clearly something was up. Why didn't you do something about it? Again, one of the cases that's come out relatively recently, for those remembering the golden rule of you need to get a capacity assessment for a client, no matter how offensive that might sound when you're writing a will. The recent case of Lord Justice Templeman, who set out the golden rule, is fascinating reading because he had dementia, I think it was, and he was exhibiting signs of confusion, and his will has been challenged, and the golden rule wasn't followed. So the sort of this irony that this thing that as a lawyer you're very much drilled into you, that you get the capacity assessment, to then see even the man himself who had set this out in a judgment didn't necessarily recognise in himself that there was something wrong. But his family surely did when the wills didn't fall out the way they wanted it. And again, this is where I think that it's going to be really hard going forward. At what point do we say, yeah, that person doesn't have capacity? The flip side, Mental Capacity Act's brilliant. Assume capacity until proven otherwise. Task specific. That's lovely. Makes life very hard though, because when do you say that, sorry, that's not good enough? In the morning, in the afternoon, this week, next week? Yeah. Robin's question, Janet's suspicions of Paul financially abusing his father. It's really sensitive, isn't it? Because when is it financial abuse and when is it supporting? I think that all we can do, it depends again when how you're coming across these clients. Are you coming Are you advising them and you're seeing large amounts of money going out of the account? In which case that you can be alert to suspicions, or are you seeing somebody who's authorizing this kind of help because it makes their life easier? I think it's maybe just checking in. Again, it's this: are you seeing your client regularly? Is this a one-off? Are you able to spot a pattern? Clients, if you're over a period of time visiting them to take instructions, have they become more dishevelled? Have they become more vulnerable? Are there signs of neglect? It might be that their finances aren't being managed correctly, and ultimately it could be theft, in which case it's a criminal offence. And I think that we're all, as sort of lawyers, financial advisors, and other things, a lot of us feel under an obligation to sort of try and fix it. But maybe you have to say, I suspect there's an offence being committed, and it's a criminal offence. Ultimately, we can fall back on theft. So again, as everything, there's grey areas all around. Jeanette, emergency funding and the windfall, yes. The quietly under the radar funded nursing care increase. I was surprised. I wasn't expecting to see that. Been talking to a few people and saying, you know, are you getting this? Is the home getting it? So one of these really contentious points about funded nursing care is, what does the contract say? When somebody goes into a care home, what are you paying for? Are you paying your £1,000 a week? And if you then get funded nursing care, that £1,000 is reduced and you only have to pay the difference? Or does that funded nursing care go to the care home on top? A lot of care homes will say, well, when I admitted you, you didn't need the nursing care. Now you do need it. The home should get it. But then we have to go back to when somebody's discharged or enters care, what level are they going in at? Are they going into a residential care home, or are they going into a nursing home? In which case, really carefully looking at contracts is really important. I often say to people, you know, well, you wouldn't buy a house and rent a property without hopefully reading the contract, and yet you'll happily sign up £1,000 a week plus, depending on where you are, without looking at the terms. Talk to the care home. Who's getting the money, if anything? Using PPE, well, it's a really interesting point. I think that's bleeding into another area of law entirely, where you're looking at employment rights, you're looking at health and safety, you're looking at health and safety of the staff, the residents. You know, CQC's been looking at things, health and safety executives looking at things. I think ultimately we're at the beginning. I think we're really going to see a lot of fallout from this. And then questions to ask of the regulators, conspicuous their absence. I think nobody knows, do they? So we're all doing our best to do the right thing, and stuck between a rock and a hard place. You're trying to do the right thing by your client in the very difficult circumstances that we find ourselves in, and you are still regulated by your regulatory body, who don't know what to do either, but can still say, well, the onus is on you. You knew what you should do. So yeah, keeping an eye out on health and safety, CQC, all of this. Something that was pointed out to me the other day that I'd completely overlooked is that you've got people who are living in sort of housing association, sort of sheltered housing, maybe something like an Abbeyfield. If they're not regulated and registered care homes, then they sort of fall between the stools. So you don't have the sort of hospital oversight, you don't have the registered care home oversight, the people who are living in these type of accommodation, who's regulating them, what's the PPE requirements, the onus is on the manager. So clients who are perhaps in that sort of very early stages of vulnerability, where's the regulation? Whose responsibility is it on whose shoulders is it? I don't have the answer, but it was something that, you know, I just struck me when I was told that you've got all these housing associations and nobody knows what to do. So yeah, so that's all the questions. I'm happy to take any more, but I feel I've sort of oh, there we go. We've got Chris. So good point about the self-assessment terms. Yeah, bringing in a third party is a really good idea. We can often act as a Trojan horse. I don't know if anybody else sort of feels like that. And I was certainly saying to clients the other day, I said, you know, they were like, oh, I'm a bit worried about how to start the conversation with my children. And I said, just said the solicitor said. They went, that's really useful. Because they said, we can blame you. And I said, absolutely, you can blame me. And yes, use your toolkit, use your black book of contacts, use your sort of use your referrers. If you've been sent work by another professional, just give them a ring and go, you might just want to have a look into, you know, something. I've just got a hunch. Obviously subject to confidentiality, but you know, if you know doing this job where things are going wrong, you know where things aren't quite right. And there's I was listening to Baroness Finlay doing a talk, and she's feisty lady, and she said, you know, if you're a doctor, you know when you've got somebody coming in, you know from your training, if they smell of certain things, what their drugs they're taking are or what their illnesses are. And she said, you will know without having to talk to them what's wrong. They don't smell quite right. And you know, if you're doing your job properly, when things don't smell quite right. And what do you do with that? And there's always a fine line to be drawn. So really, it's picking up the phone, asking a friend, and if in doubt, there should be some sort of authority you can fall back on, particularly with things like the OPG. They are a government department. They have a register. They have a safeguarding helpline. I think you just give them a ring, see what happens. So yeah, I'm going to wrap it up. I hope that sort of gives you a bit of a rattle through what I sort of see coming across my desk. And I know that conversations I have with colleagues, you know, who are on here today, that we've thrashed out similar problems in the past, entirely confidentiality. And I think, you know, we're never going to get it right. We're never going to be able to take that risk away. We can do our best, though, to reduce it. So all I can say is thank you very much for your time and all the questions. That's fantastic. Always happy to be a sounding board. Always happy to be on the end of the phone, email. Yeah. So thank you very much.